Case number 25-050805 Credit Union versus Teresa Davis Seals.
All right, appearances for the record, please.
Good morning, Your Honor. Elizabeth Butler, P80956 for Plaintiff by Credit Union.
All right, good morning, Ms. Butler. And ma'am, what is your name?
My name is Teresa Davis Seals.
Okay, and good morning to you as well. Today is the date scheduled for 2 hearings, I see. We have a motion for summary disposition that was filed by the plaintiff, and then I'm looking at a letter which indicates that Ms. Davis Seals is requesting a motion to dismiss the case. So we'll figure out which one we would like to address first, but I'm thinking let's go with the defendant's motion first. Ms. Davis Seals, what's your argument?
Okay, Your Honor, I would like to say that Ms. Butler has no case, and the information that she has compiled in her packet that she does have, it basically has come from me, from the mediation that we had of my receipts. She has no information, and she's now wanting this hearing to further get additional information from me to work against me, which is ridiculous. And I only came to this hearing today just to find out more about Ms. Butler and her affiliation with this credit union, why she's even with them, why is she working for this particular situation. I have no dealings with her and her organization or her company, and I see no reason to even be having this whole case situation to begin with. I tried working with that credit union one-on-one myself. It was not necessary for them to take this route, and now they have put her out here, not equipped, because she doesn't have any information. They didn't give her any, and now she wants to use me to work against me, which is crazy. This is why she wants this meeting today. She wants to hear additional information, and I purposely left my information at home. I have additional information other than this makeshift packet that she put together, and I purposely didn't bring it because, as I stated, I want to hear more about her affiliation with this company, and to let her know that the information that she does have is inaccurate.
You are stating the company's records are wrong, yet you didn't bring the documents you say prove it. If this was an honest mistake, show me something credible in email. A timestamp.
Well, now you've asked me to dismiss the case, and in order to do that, we would have to have a legal basis to do that. And I hear that you're not happy with the fact that she's filed the case. You don't understand who she is. You don't like the fact that she's got information from you that she's using in the case, which, by the way, that's okay. Either side can use information from the other side. As a matter of fact, that's a process that we call discovery. And it is authorized under the Michigan court rules that you can ask each other specific questions about your side of the case or their side of the case, whichever you want. Any factual information, questions can be asked. You can ask for documents. Documents can be provided both ways, from the plaintiff to the defense, if the defense wants to see documents that the plaintiff has, and vice versa. So that part is technically okay. But for you to ask me to dismiss the case, I just can't dismiss the case. I have to have a legal grounds to do that. And I'm not really hearing specific legal grounds, although I am hearing some other things that you're not happy about. So,
Your Honor, can I say something else? I just want to bring out all of the rest of my feelings and information and everything concerning this case on September the 25th for the trial. As I stated before, the reason I don't want to keep giving information pertaining to Ms. Butler here is because she has no information and she's trying to use me to build the case.
Ma'am, that's okay. That happens.
She
You
should be talking to them, not me.
Well, let me say this. It's if this case gets to trial, it is their burden to prove the case. But they can do that by any type of information, whether they got it from you, whether they got it from their client, the credit union, whether they got it from answers that were filed to interrogatories or your response to the complaint. That's okay. That's the way a lawsuit progresses. So it's not like she's doing anything wrong, but if she is using information that she obtained from you.
Well, Your Honor, she's not giving me any. When this
Did you ask for any information?
Yes,
Okay.
she didn't even answer her phone when I called.
As far as I'm aware, there's a very clear and formal process for requesting discovery, and it definitely does not rely on vague stories about missed phone calls, courts.
Ma'am, let me tell you, there is a written discovery. I don't even know if the court had ordered it before, but if I did, there's written discovery that you can use to actually ask for information. Now, from what I'm seeing here, this got filed fairly quickly, this motion. So I'm not even sure that we even did a scheduling order for discovery yet. They filed their motion for summary disposition, I think, before we even got to any of that. And I'm not even sure if you went, maybe you went to mediation. You did go to mediation. Well, at least it was ordered in July. Let's see if you went. I don't know.
Yes, Your Honor, we did go to
We had
mediation.
mediation.
Okay. So usually after mediation, can somebody tell me the date you went? Because usually that's when we would do a scheduling order.
I think it was August 14th.
Okay. So I don't see a scheduling order back yet. This motion got filed though in August.
Your Honor, may I respond to the defendant's motion, or do you even need me to file?
Yeah, well, I'm gonna let you say what you need to say. I just wanted to make sure she was clear on the fact that some of the things she's complaining about are okay. So go ahead and respond, Ms. Butler.
Thank you, Your Honor. I mean, you said that there needs to be a legal basis for a motion to dismiss, and thank you for explaining that my client's entitled to ask for information from her. We attended the mediation, and I had asked her for copies of checks. I wanted to make sure my client had the right balance, that she was giving credit for all of her payments. She kindly provided that, and my client reviewed, and we filed our motion for summary disposition based on the balance, and we included a full accounting with the motion. That's what she had wanted to see, and she was served with a copy of the motion. I'm happy to
Let me interrupt you a minute. I'm looking on my electronic filing and I see the motion itself, but I don't see, let me see if there's a brief. I was looking for the brief and I couldn't find it.
We filed a brief with exhibits and a proof of service and a notice.
Okay, let's see. I do see something that says exhibits, so let me see if that's it. Yes, you're right. Says exhibits, but there's the motion. Okay, there's the, well, no, here's the exhibits. Okay, let's see if I got a brief with it. Okay, I've got all of the exhibits that you've attached right here. And it just says exhibits, but there's no motion. Let's see, notice of hearing and, there's no brief. I've got the motion, which is just your standard motion, but I don't have the argument. Do you know what date that you filed the brief?
On August 18th, the same day we filed the motion and those exhibits.
Okay.
Have
So
filed
let
stamped copy.
let me look at everything from August 18th. So here's the motion. And the motion does not have anything else attached to it. It's just got a motion. And it appears to be about 2 pages. Then there's a notice of hearing from the 18th also. and that's one page with a date to be determined by the court. There's a proof of service from the 18th, which says everything was served on August the 18th. That's also just one page. Then on the 18th, here is a proposed order. That's one page. Then the next document. Aha! There it is. I must have missed it before. Here's the brief.
No problem, Your Honor.
Okay. All right, go ahead with that, your argument then. You've got your documents attached. I see those.
Yes, Your Honor. This relates to a loan that Ms. Davis Seals took out with my client, the credit union. She seems to be under a misunderstanding that my office owns the debt. We're just the lawyers for Provide Credit Union. They still own the debt. We're not a separate debt buyer in any way. We're just humble attorneys.
Yeah, you're just representing the credit union.
Correct.
Mm-hmm.
Ms. Davis Seals had a loan before this loan that's the basis of the lawsuit. The loan that's the basis of this lawsuit was a debt consolidation loan, where she was given a new loan. So Ms. Davis Seals had made payments on that prior loan, and my understanding is that she's concerned she didn't get credit for those prior payments. I think what she's not understanding is that this was a new loan, and the payments made before don't apply to the new loan. The new loan encompassed all her prior payments and what she'd owed before. After mediation, she kindly provided my office with copies of her receipts. I had my client double check everything to make sure that all her payments were credited. She had admitted that she missed some payments, which is the basis of the default on the loan. Attached to the motion for summary is a full accounting of all her payments and also an affidavit of account from my client confirming the balance. That was the basis for the motion for summary. She doesn't seem to be contesting that she took out the loan, that she owes money. She just was worried about the payments, thus the full accounting affidavit of the balance. I'll also point out she hasn't filed a response to the motion. Maybe if you want to consider her letter a response to the motion, she still has not presented any genuine issues of material fact that would justify a trial, nor has she stated any valid defenses. This motion is under 2.116, C9, and C10. If she doesn't present anything that would contest this balance, there really isn't much more for the court to review based on what we've already provided. That's why we ask that this court consider denying Ms. Davis Seals' motion to dismiss and granting this motion for summary disposition. Again, there's really nothing to review further at a trial.
There actually could have been more for the court to review if she hadn't accidentally left the paperwork at home. And let's be honest, that didn't feel like an accident. That was a calculated move.
All right, thank you so much. Okay, so Ms. Davis Seals, I'm going to give you a chance to respond, but the gist of her argument is that, number one, she's just the lawyer for the credit union. She's not trying to collect the debt for any other entity other than the credit union. And that's how she's involved in the case. Number two, she indicated that at the mediation, she got your documents to make sure that you were credited for any payments that you had previously stated that you made, and that there was a prior loan, and then you got this new loan for debt consolidation. And they verified that all of your prior payments were indeed credited to the other loan. And this is a new loan, and that you've admitted that you pretty much owe this loan. There's no question there that you owe that debt. You had missed a couple payments, so that's the default. And otherwise, she says she's checked her balances, and this is the correct amount that's due, so that there really is no issue to go to trial on. And if there's no issue to go to trial on, we could enter judgment for the credit union today, because there's no issue. A trial is held when there are actual issues that we're not sure, well, what's the facts? This case, she argues these are the facts. No one's disputing the facts.
I'm disputing. Your Honor, let me speak on each one of those issues you just mentioned. Number one, this is a debt collection agency that's working for them. They have bought out this account from this credit
Ma'am, there's
union.
no evidence of that.
That they have. The paperwork that I
excuse-
read, let me finish
excuse me.
talking.
I need you to, I have to be based in reality here. So I need you to show me what documents you have that support the fact that they bought the debt and that they're actually the people collecting it, because the lawsuit is not in the name of the law firm. And it's okay for a debt collection law firm to represent the credit union because the credit union is trying to collect a debt. And they typically do hire debt collection firms to do that. So
Okay,
you
Your
have
Honor,
to-
let me
ma'am,
finish. Let me finish.
Ma'am, you can't say that to the judge.
listen,
Okay,
I'm sorry.
sorry.
I'm sorry.
Okay,
I'm not there.
okay.
And I'm not going to try to overtalk you.
Okay, I'm sorry, Your Honor.
And I'm the one that knows what's going on. I understand the law and I understand this process. And I've looked at these documents and I'm trying to explain it to you. But if you want to overtalk me, that's not going to work. Now, I'm fully happy to listen to anything you have to say. That I am willing to do. But if it's not right, I'm going to have to tell you that. And we got to move forward from
I
there.
understand.
Okay, go ahead.
Okay, so here's the whole situation. I took out the loan and I did that. It was a double loan. I started with one. They merged that first one in with the second one. It became a combined one loan.
Welcome to the world of debt consolidation, a system that markets itself as financial relief, but often translates to let us collect all the interest instead. At first glance, it sounds smart. Roll all your debt into one loan with a lower rate. But behind the sales pitch are steep fees.
Out of that one loan, I have paid over $8,000 and plus dollars for that whole loan. It became a consolidated one loan. And they are not accurately giving me the credit for the amount that I have paid.
Okay, ma'am. Well, you're going to have some documentation to show
I
me.
have it. It's at home. Like I said, I didn't bring anything.
Today was the date to bring it. We don't get to trial when there's a motion pending. And in order to actually respond to the motion, you needed to have brought your information today.
It was my understanding this was just a hearing before the trial.
It is a hearing before the trial, and it could end up that you don't get to trial if her position is substantiated.
Well, it's not accurate. They have false information regarding what I have paid, and everything else that she's saying about this, what they have done is false and against what is actually true.
Okay,
and
ma'am.
I wanted to bring out all of my information
We don't have
during
it.
the trial. That's what I thought I could do.
We don't get there. This is the date to do that. This is a motion for summary disposition. That means this is the date where the case could be totally dismissed, and we don't get to trial based upon their motion. This was the date for you to file a response, like she said, which you did not do, but that's okay. If you had brought some information today, we could have dealt with it orally to some degree. But if you don't have anything, I can't just go on your word that they did something false.
I have it
I
at
gotta
home.
have documents. Ma'am, you were supposed to, I don't know why you would come to a court hearing without the
Because
proper.
I thought this was just a hearing, that we were just supposed to voice. It was another, I thought it was similar to that orientation we had, which, by the way, she started with one sheet of information. Then all of a sudden, after I submit my receipts, she comes with a bogus packet, of which over 99% of this packet is incorrect. And this is why I thought this was just another hearing to voice why it should go, like you said, go any further or not, because none of what she has in this packet is correct.
And I have no evidence to show that none of what she has in
and
the
I'm
packet.
sorry, I made the mistake.
incorrect.
It's at home. I have the information to show it.
If you claim to have evidence but left it at home while standing in front of the judge, then for the court's purposes you effectively have nothing. Evidence only matters when it's properly presented in that moment, not when it's sitting somewhere else. A courtroom operates on what's submitted, not on what someone says they could have brought.
They have the accurate records of how much I have paid, but not giving me credit for it. I do not owe the amount that they're saying, and I should not be assessed anything any different. This is a collection agency that has gotten that account. They want to take it over and want me to start from a whole big balance amount, of which is not true. I have paid this credit union over $8,000, $8,231.07. And they are not giving me the credit for it. And then they want to continue on with a huge balance. How can you come with a balance of 11,000 plus when both of the borrowed amounts were 7,000 each, and I have paid over $8,000 plus?
Ma'am,
There's
I don't
only
know. You have to look at-
3,500 left.
You have to look at the terms of your loan agreement. I'm sure there's interest and penalties on late payments that apply.
And that's another, I'm glad you mentioned that, Judge. And what she said earlier about missing some payments, I've never missed. I've been late, and I admit that. But the late ones I have gone up with and moved forward. There's no way I could reach $8,000 plus not paying. I have paid late. I've never missed. So that's an incorrect statement that she has made. This credit union is crooked and biased, and is sorry for that she's representing them on those premises, but that information that she has given is incorrect. And like I said, I didn't understand. I thought I could bring my information to the court. I thought we would be having a case on the 25th of September. And so my information is valid, but it is at home, because I thought she was trying to continue to get more information from me to base her case.
Now, if you had read the motion, it says in the body of the motion that she's asking the court to enter a judgment against you today at this hearing. That's what the motion says. It doesn't say she's trying to get any information from you. It says she's looking for a judgment. And if she gets a judgment, that's the end of the case. There is no trial.
Well, Your Honor, I would still like to request the trial to go through for the 25th.
I can't do that, ma'am.
Allow
I
me
have
to
to
do-
resolve the motion today. I can't do that. That's why she filed the motion.
It's inaccurate, and it was not my clarity. I had a lawyer through the Lakeshore situation, and they completely just dropped me midstream, no assistance. And when I came back in, they later came out here. They came to the court and were meeting people downstairs. I asked why was I dropped. They could not give me a valid. Only thing the lady said was, well, we're short-staffed. But yet they had started in the middle of my situation. It's unfair to me to have taken on this type of a situation by myself. I had my legal help that I thought I had snatched completely from under me for no real valid reason. They had already started. So to tell me that they were short or they have a lot of people, that was an injustice to me, because they had already started assisting me.
I don't know all the details here, but let's be real. If you had an attorney handling your case and they suddenly withdrew, it usually comes down to one of two things. Either you stopped paying for their services, or you never paid them properly in the first place. Attorneys don't just walk away for no reason. Because if you did pay and they dropped your case without...
And had I known that this meeting today was going to involve my not going on to the 25th of September, I would not have made that mistake. And that's where legal defense comes in, and I've been done a grave injustice where this, ever since this mess here has started regarding the lies regarding what I have paid to this credit union.
Okay, let's hear back from the plaintiff before I resolve this.
Your Honor, the only point I'll bring up is Ms. Davis-Seal said she never missed a payment, she was only late. Being late on a payment does still constitute a default under the loan agreement. She was late on a few payments and made them, but she also, from the transaction history attached to the motion, missed a payment in August of 2023, October of 2023, and a short payment in March of 2024. That's all in the transaction history attached to the motion. Thank you, Your Honor.
Your Honor, may I say something?
No, ma'am. At this point, I gave her an opportunity to respond back to you because she has the burden of proof. Because we can't go back and forth like this all day. So I've given you a chance to speak, and we're now looking at her motion, and she's argued her motion in conjunction with her response to your motion to dismiss. As far as your motion to dismiss is concerned, I'm going to look at the body of it again, but it really doesn't have a legal basis in it for the court to grant you a dismissal of the case. What you indicated in the motion and on this record today is that you're being sued, of course, by a Vibe credit union, that this lawyer is representing them. That's all true. That you had tried to work things out. That's probably true. None of that's a basis to dismiss. And that you are no longer, you found out that about this case, and now they're using the debt collection firm to represent them, that you're not interested in going further with trying to resolve it, I guess. You say that Miss Baker's agency is a farce, trying to collect money because they now own the account. There's no evidence of them owning the account, and they have not filed this lawsuit in their name as a debt collector for them to try to collect the money. They filed this in the name of the Vibe Credit Union to try to collect the money for that client. So there's no evidence that they bought the debt. There's been no transaction history showing an account purchase from Vibe or anything else. They also, you indicate that you were informed by a source of how debt collection works, and that is probably accurate. They just not collecting the debt for themselves. It's probably true. They do buy debt. It happens. We have cases like that every day, and there's usually a purchase of an account, an assignment of interest, and we can track the chain of title down to the plaintiff. That's not what's happening here. The plaintiff's law firm.
Can I make another statement on what you were saying just now about?
Ma'am, I'm trying to rule, and when I'm ruling, that's it. Nobody else.
I didn't know you were ruling. I thought you were just reading.
No, something. I'm going through your points to make a clear record of why I'm about to deny your motion to dismiss this case.
And the business, we call this foreshadowing.
So yes, they may buy debts, but that's not what we have here.
Mm-hmm.
You say you don't owe the debt collection agency any money. That's probably true. And they're not looking for money from you. Vibe Credit Union is looking for money from you.
I'll just call you.
You indicate in here that there's some false allegations. I don't know what those are. You're still talking about purchasing of business records. There's just no evidence of any of all that. You've got that into your head, but there's no evidence of any of that. And basically, we get down to it. You think they've disregarded your receipts. It's the similar things you're arguing on her motion, but that's not a basis for me to dismiss the case. So anyway, you say you feel it's unjust, but you had a loan with the credit union. And so they have a right to try to file a lawsuit if the loan agreement was breached or defaulted in some kind of way. Then that's what they've done here. So that's no basis to dismiss the case. And I don't see anything unjust about that filing of a case if they have a loan agreement with you that was allegedly breached. So anyway, you asked me to sincerely consider this request, which I did, and I do not see a basis to dismiss the case. So your motion to dismiss is denied. As far as the motion for summary disposition is concerned, it's brought under Michigan Court Rule 2.116C10, the basis of which is that there is no genuine issue of fact that requires a trial. This motion was served upon and filed with the court and served upon the party defendants at least, let's see, at least 28 days ago, specifically it looks like it was on the 18th of August. So at this juncture, the defense has had notice of the motion, notice of today's date. She's appeared here today. She could have filed a written response to the motion. She did not do that, but she appeared and made her argument that there's some kind of fraud she thinks that the credit union is perpetrating against her. She's made her argument that she was not fairly credited with a number of payments that were made on her loan, and she brought no proof of anything today. And this is the date of the hearing where the proofs should have been brought, because in a motion for summary disposition, the plaintiff has the burden to bring forth some evidence, and once they do, then the burden shifts back to the defense to bring forth additional evidence to refute or rebut the plaintiff's evidence, and therefore creating a question of fact for trial. We don't have that here today. There's nothing here that shows.
Here it is, Your Honor, here it is.
Ma'am. Here's what?
I just found it. It's in this packet. I thought I just had her information, but my information about what I paid is here on this sheet.
You've got to be kidding. You're standing in front of a judge, and only now you mention that you don't have the paperwork you were supposed to bring. You had all this time to prepare, and you waited until the judge is literally about to make a ruling to speak up about it.
And quite frankly, let me take a look, because I don't have that. And everybody is required to provide in advance. That's why we give all this time for these motions to be heard, so that everybody can review it and see it, including the court. I've got all the documents I need in my file right here, except for what you got there. And you're asking me to look at something that I can't even look at this point. So I'm going to ask counsel, could you please grab what it is that she's got and tell me if you've looked at it before?
Your Honor, I have not seen this before. It looks like a handwritten ledger. Again, like I mentioned, Ms. Davis Seals had provided to my office all of her receipts. And
does that look like a listing of the receipts similar to what you went through?
Yes, Your Honor, it does look similar. She had provided the ledger and copies of her receipts before. My client double checked, made sure she got credit for what she had made. This does not look different to me.
So specifically, ma'am, you would have to then show me, because I'm going to look back at her exhibits. Which one of the exhibits has your full check of all the receipts?
Your Honor, it's exhibits 2 and 3 that have a full transaction history. And then exhibit 4 also has all the statements that would have been mailed to her. So if there ever was anything missing, she would have had the opportunity to tell us. But again, she already provided all her receipts to me. I did not include them as an exhibit to the motion because my client executed an affidavit, having reviewed the business records and indicating the balance.
Okay. So let's look at exhibit 2 and 3. And just so it's clear, I've got 43 pages of exhibits from the plaintiff here.
Sorry about that, Your Honor, but we felt it was necessary given what her concerns were.
And you just have to wait a second because the online system must be very busy today when other courts are using it, and so therefore it's frozen.
Your Honor, can I make a statement? I have another statement I'd like to make regarding the rest of my evidence that I told you I left at home.
What is it?
The other evidence is that they keep arguing the point that I only had one loan, but I had 2, and that's what I was going to be bringing out.
She said you had 2 loans.
She said 2.
She did. She said you had a previous loan.
The 2 combined then are the ones that show that it was a one amount and that all of the monies that I paid towards that one account was not accounted for because there were 4 in the first contract before they blended in with the second one.
I don't know. She said it was a first loan, and then she said it was a debt consolidation was the second loan. I believe that's what she said. So, and she said all the payments that she saw that you made were properly credited to that first loan that you made.
They were not. They were not. Otherwise,
Well, tell me which one was not credited.
None of it. Really much.
None of it.
All they have me credited for, according to their balance, is $2,000 and something, and I paid $8,231.07.
As I mentioned before, debt consolidation companies can be just as predatory as the original lenders and in some cases even more aggressive. Their entire business model targets people who are already overwhelmed by debt and struggling to manage their finances. With clients.
So in their paperwork, when they give the final tally and total of what the remaining balance is, they're still saying that it's 11,000 plus. If the 2 combined came to 1344, something of that nature, and when you take 8,000 and something from that total amount, you're gonna end up with 3,500 or so. How can they still be coming up with 11,000 plus when I have paid 8,200 plus?
Okay, I'll let her answer that again. Go ahead.
Your Honor, maybe this will help. If you look at Exhibit 1, which is actually the loan agreement, on the second page of it, at the very top, I'll let you get there, so it's probably easier once you're there.
Okay, what's the very top say?
Itemization of the amount financed. You'll see that she financed $13,644.13. That's page 2 of the loan agreement. It says amount given to you directly, $7,000. Amount paid.
I'm missing something. I'm looking at something different then. Let's see. I'm looking at Exhibit Index Loan Agreement, Exhibit 1. Then here it says Exhibit 1 Loan Agreement. Then the next page says loan and security agreement disclosure statement.
Go to the next page after that. Your Honor.
Okay, that's the second page then.
No
Okay,
problem.
there it is. Itemization of amount financed. Go ahead.
$13,644.13 was financed. Amount given to you directly, $7,000. Amount paid on your account, $6,644.13. So she thinks she paid $8,000. I think she's considering the $2,000 or so she's made since this loan atop the prior loan's payments. I think that may be where confusion lies, but my client did lay this out right on the loan agreement.
And it shows 6,000, which was what she paid on the other loan. Is that what you're saying?
It's representing that other loan was paid off to the amount of $6,644.13.
Right. And she
And
got $7,000.
Yes, Your Honor, and the interest rate on this was 14.99%, so that accounts for this balance going up. There are also fees for late payments. The interest dropped to 13% as of the date of filing of the lawsuit as required by statute.
Okay. Ma'am, I don't understand. It shows right here on the document.
Those papers are inaccurate, Your Honor. They're inaccurate. I said that when I first started out, I said she had no accuracy in her paperwork. And I said, and I'm sorry that I had left mine.
Okay, let me say something to you. This is a document that you would have signed.
I have the signed ones.
No, you what?
I have the signed ones.
No, you didn't. You didn't have to take the loan.
No, I'm saying that I do have signed accuracy. What they have come up with is since this dispute, they don't have. She doesn't even have the first copy of the
Ma'am, it seems
phone.
to be.
She has none of it.
It seems to be your payments seem to be in the disclosure statement.
That's what they're saying.
Okay.
Well, you
Like I
signed,
said,
ma'am. I'm looking at your signature on it.
I have accuracy.
How you gonna say this is
both
inaccurate?
sides
And you
because
signed
they
it.
have doctored it. They have doctored it to say what they wanted to say.
So let me get this straight. You actually have documents that could dispute their claims, but you left them at home. At this point, it's like walking into a storm without an umbrella. And without those records in the courtroom, the judge is left with only one logical direction to base her ruling on the evidence she does have in front of her.
I have the
Ma'am,
two
listen, I'm gonna
access
have to go
contracts.
ahead and finish ruling on this. I'm gonna end up having to grant this motion for summary disposition. There's just no basis for what you're saying. I'm looking at the original loan document for this, which seems to take into consideration the payments that you made previously. And then you've already made some payments on this loan agreement as well, which equals the amount that you're saying you paid. And it's all shown here.
No, it's inaccurate. Those
All
are.
right, well, I don't know, but I don't see any genuine issue material fact other than you complaining that it's inaccurate. I don't
No,
see
it's
anything.
not. I
You haven't
wouldn't
showed me
make that
one
up.
thing that's inaccurate, so therefore the motion is going to be granted. If you think there's something wrong, I'm so sorry, but you do have a right to appeal, and you might want to go downstairs and appeal to a higher court within 21 days of today's ruling or whenever this order gets entered. But there's just no issue here that I can see that would require an actual trial here. So I'm going to ask the plaintiff to please prepare the order on both the motion to dismiss being denied and for the reasons stated on the record, plaintiff's motion for summary disposition is also
Yes,
granted.
Yes, Your Honor, thank you.
Okay, and that's going to complete this matter.
All right, everyone, that wraps up today's video. I don't want to make any assumptions here, but I'm almost certain I've covered the Davis Seals family from Michigan before. And if I'm remembering correctly, they've been heavily associated with sovereign citizen behavior in past cases. Now, I didn't want to bring that up earlier because she didn't really lean into any of that during this hearing, but it could explain why the original law fame